Okay, everyone, please find a seat. Come back into the room when you finish getting your coffee. We're going to begin the next panel, which is the risks of workplace injury and non-standard work and policy options. My name is Michael Grabell. I'm the moderator for this panel. I'm a journalist for ProPublica covering economic and labor issues, immigration, and trade. In reading up for this panel, it was interesting to find that jobs as we know them, where people work for an extended period of time within an organization, have really only existed for about 150 to 200 years. But the concept of injury compensation dates back to 2100 BC, when King Ur-Nammu of Ur decreed that a man should pay a certain amount of silver for causing the loss of a foot, 10 shekels, or a smashed limb, 1 mina. So this gives us hope that the changes and the challenges that we see today are not insurmountable. I'd like to briefly introduce our panel members. John Ruser is president and CEO of the Workers' Compensation Research Institute, and before that was at the Bureau of Labor Statistics. David Michaels is professor in the Department of Environmental and Occupational Health at George Washington University's School of Public Health. And before that, from 2009 to 2017, he was the Assistant Secretary of Labor for OSHA. David Torrey is a workers' compensation judge within the Pennsylvania Department of Labor and Industry, and is one of the most prolific authors on workers' compensation law that you can find. Jennifer Wolf-Horejsh is Executive Director of the International Association of Industrial Accident Boards and Commissions. She works with industry professionals from around the globe to identify emerging issues and to find solutions. Their full bios can be found in your conference folders, and following the remarks, we will have some time for Q&A. So to ask a question, again, a reminder, there are question cards on the tables, so please use them to write down your questions throughout the session. Our staffer is then going to circulate them around the room and bring them to me to announce. Before we begin, I wanted to provide a news peg for this panel. As a journalist, I always try to find the news peg in what we're doing. And within the last few weeks, there have been two legal decisions related to non-standard work and injury compensation or workers' comp. In Oklahoma, the Supreme Court overturned a law that barred contractors from filing lawsuits against the oil and gas well operators. They now have that option. In Wisconsin, an appeals court said that temporary workers can elect whether or not to use the workers' compensation system or to file a lawsuit. So I bring these up to make the point that there is a business case for getting some certainty around this, and that what we're talking about today is not just pie in the sky of how do we address this growing workforce. So with that, I'm going to invite the first panelist, John Ruser, to come up and speak.
Thank you, Michael. So this panel is dealing with injury risks associated with non-standard work. And when I was presented with the topic, I thought one thing was going to be discussed, and other folks thought another thing. So what are those two things that we're going to talk about on this panel? First, we're going to talk about the actual workplace injury and illness risks that workers face when they are working in non-standard work. And then we're going to talk about the risks associated with coverage by workers' compensation. That is, the risk that you are not covered by workers' compensation when you work in a non-standard job. So a couple of us will talk about the injury risks, and a couple will talk about the legal aspects. So many forms of non-standard work actually have higher risk of injury and illness. And to exacerbate that, many non-standard jobs also are not covered by workers' compensation. So I'm going to mention a little bit of evidence about injury risks on non-standard work. Interestingly, there really isn't a lot of data that gets to the point about whether or not non-standard jobs are at higher risk of workplace injury and illness The federal government's workplace injury and illness statistics program that I used to head doesn't really do much to sort out the injury risks faced by folks who are, say, in contract or independent contractors versus those who are not. The Census of Fatal Occupational Injuries does have a contractor field, but not a lot of work has been done to compare like jobs to answer the question, is a worker, an independent contractor who's doing the same job as a standard employee at higher risk? There is, however, a little bit of evidence from the workers' compensation data. In fact, our moderator, Michael Grabell, has done some of that work, and the work is based on comparing the workplace injury and illness risks faced by temporary help workers who are covered by workers' compensation against standard employees who are also covered by workers' comp. And the finding from the ProPublica work that Michael Grabell's associated with is that in a couple of states, and this is an example because there are several other states covered by the work, in Florida and in California, the work comp data shows that temporary workers have about a 50% higher risk of being injured on the job than non-temps. A similar study in Washington State, again, using workers' compensation data, showed that temp agency workers were at twice the risk of a workers' comp claim than were permanent workers. So there's some pretty clear evidence that workers who, at least in working in temp jobs, are at higher risk of injury and illness. And I'm going to talk about, you had a nice panel that talked about some of the different attributes of non-standard work, the heterogeneity in that work. I'm going to lump non-standard work into two different buckets when I talk about injury and illness risk. There's the folks who work at variable jobs, at variable places, as a temporary help worker, maybe as an independent contractor. So that's the group that are sort of temporary workers at a particular place. And then the other basket that I'm going to focus on is injury risks associated with flexible work schedules and non-standard work hours. So this slide says contracting out is growing. At least it's shown that that's true in some of the jobs data, though, as you saw from some of the household data, there's some questions about the growth in contingent work. I'll just skip this one. So why is it that temporary and contract workers often work in less safe jobs? There's actually a lot of different hypotheses out there. One has to do with their experience on the job. The folks who are temporary and who are contract workers often have less experience and familiarity with the workplace, and government data are pretty clear that workers with lower amounts of tenure on the job, and this does come from BLS data, often are at higher risk of injury and illness. When a temporary worker or a contractor comes on a work site, they often don't have the same connection with permanent workers than, say, another permanent worker would have. Well, those permanent workers know about the job risks on the site. They're able to warn about some dangers on the job site. And the more distant relationship that the temp and the contractors have means that they're not going to learn about those job risks. Often it's the case that the temp workers and the contractors simply don't have the same amount of training around workplace safety and health. Though I will note that in some cases it's been argued that there are some situations where a contract worker may actually have a lot of expertise in a fairly narrow area and may be able to avoid injuries and illnesses that, say, just a temp worker would not be able to avoid. There's also a lot of evidence that more hazardous jobs are assigned to temporary workers and to contractors. There are stories about independent contractors going inside of big fuel tanks and suffering from explosions in those tanks. Those jobs are contracted out because they are dangerous. Some other reasons why temporary and contract work is often less safe. Many of these employees are in precarious employment situations. They're going to be concerned about what might happen to them if they report unsafe working conditions, and so they don't, and so sometimes they sustain workplace injuries and illnesses as a result. When it comes to certain kinds of workers, say those that are temp workers, they essentially have two bosses, the one at the job site and the one that sent them there, and there might be some lack of clarity about who should be in charge of the worker safety and health. Sorry. And finally, there is a situation about exposure at multiple work sites. Often these workers are not working at one site, they're working at many sites. And so they're subjected to the workplace risks at those different sites. There's some issues around what was the site associated with the injury, and in some cases maybe with cumulative trauma and that kind of thing. In fact, there is no one site that's associated with the workplace injury. So some of that has to do with who owns the injury and who should be doing something about it. It's a challenge when there's multiple work sites. So let me just finish by talking a little bit about flexible work schedules and flexible locations. They often are associated with higher risk. First of all, non-traditional work sites might be outside of OSHA jurisdiction, and so they're not going to get the scrutiny about safety that a traditional work site would get. And also, non-traditional work hours may be less safe, maybe because of worker fatigue that leads to injury and illness, or perhaps poorer working conditions. And the example that I cite here is poor lighting, particularly when you're doing night work. So the bottom line is that many non-standard jobs are associated with higher risk of injury and illness, and there are a variety of reasons that explain why that is the case. So that's it.
Thank you. Statistics are people with the tears wiped away. Irving Selikoff, one of the parents of occupational medicine, taught us that. And so I want to begin here with a story about a person. And this is Day Davis. Day was a 21-year-old in Jacksonville, Florida. He was a recent graduate of the Department of Labor's Job Corps program, never actually held a paid job in his life, was hoping to get a job as a medical technologist. That's what he was trained in. But he went to a staffing agency. And the staffing agency said, great, we have a job for you. Show up tomorrow morning at the Bacardi Bottling Corporation. They need someone. And so Dave went with his mother to Walmart. He bought the safety vest. He bought steel-tip shoes. Got to Bacardi, took a picture of himself, a selfie to send to his fiance, and he went to work. He was, and if you're familiar with Dave Davis' story, it's because you've read Mike Grabell's fabulous writing on that, and you may have seen the video that I'm going to briefly describe here, which Michael and his colleagues at ProPublica FOIA'd from OSHA and put up on the web. Day arrived with great enthusiasm, was given a broom and told clean up underneath the palletizer, which is an area which essentially the boxes get put together and there's a lot of broken glass because this is a rum bottling company. And I don't know how well you could see this, but it says danger, do not enter, safety first. His supervisor said, go in there and essentially get rid of all the glass. He had no training, but if you were a temp worker and you were given that assignment, what would you do? You essentially would do what he did. And the video shows that he went in there to sweep out the area. Someone else turned on the conveyor belt, and Day Davis's first day at work was his last day on Earth. And so while it's very important to talk about workers' compensation, I want to talk a little bit here about preventing these injuries so people don't get into the workers' compensation. And of course, preventing occupational injuries and illnesses is one of the great market failures of the last century. And as a result of that, Congress passed the OSHA Act in 1970, saying that every worker has the right to a safe workplace, and every employer, and that's important in these discussions, has the responsibility to provide a workplace free of serious recognized hazards. And so now we have to think about this question of temp workers, contract workers, gig workers. So I want to talk a little bit about temp workers that John started on this discussion. So the first thing is, the first reason why are they great risk, the first reasons are the ones John laid out. But it's worth talking about just briefly that new workers in general, whether or not they're temp workers, are at greater risk of injury. And of course, temp workers can be new workers 7, 8, 10 times a year. And BLS did provide some data, and I like to go back to the historical record just like Michael did. So here's a study from 1918 or 1919 that BLS did on the steel industry. And I hope you can read this. It's a little small, but essentially shows that this is injuries on a certain machine on the first day that you work, and then the second day, to the end of the first week, the second month, and the first day, the average number of people injured per day in the steel company, 460 on the people the first day they worked this machine. Later on in the week, it was 83 per day, and a year into it, it's 1 per day. And Bielsa's comment at the bottom is, it shows great excess of accident occurrence on the first day, but if this were made into a rate, it would be even more striking. So we've known this for a long time, that new workers are at greater risk of increased injury. But in addition to the things that John said, I want to frame it a little differently, which is that host employers often don't have the same commitment to temporary employees, and that's a fundamental issue. And in addition to that, the employer who bears the risk of injury in these cases, which is the staffing agency, they have the compensation costs, don't control the safety and health investment. And that's this fundamental problem. We saw this problem. We saw a number of workers like Dave Davis who were killed the first day on the job. I reached out to the CEO of the American Staffing Association, and I heard later they were quite surprised and concerned because the head of OSHA had never called them up and said, you have a problem. But I called them up and said, you have a problem. And at first they were alarmed, but then they realized they actually needed to work with us because their business model is taking people off the street, putting them in places they don't control, and hoping they don't get hurt. And we brought them in. We had some very striking meetings with them where our lawyer, they would say, well, what do I do if we hear that our workers are working in places where the machines aren't guarded? And our lawyer said to them, you have to take them out of those workplaces. And they came around to actually seeing that was valuable, and we started a temporary worker initiative where we put out a tremendous number of very useful materials with them, and so they can show host employers, say, look, OSHA says you have to treat our workers the same as you treat your permanent workers. But also, OSHA also does compliance, but also, we have a stick, which is enforcement and inspections. In every inspection, we had our inspectors say, are there temporary workers here, and what are they exposed to, and what are they trained of? And we started issuing citations because we took the position, and this is different from the joint employer discussions that David talked about, for example, with franchises. We simply said the host employer and the staffing agency are both employers of the temporary worker, and they're both on the hook for citations. And it was very straightforward, and I think it had a big impact. What's interesting is the American Staffing Association and the National Safety Council have gotten together for a voluntary accreditation program where staffing agencies go through certain hoops to make sure their people are safe. It's a voluntary program. I'm not sure how effective it is, but I think it's a step forward, but certainly not enough. The next issue is around these multi-employer sites. We've talked about that, very common in construction, but everywhere we would go, we'd see employers and with traditional employees, contractors, subcontractors, so-called independent contractors. The BP Texas City explosion in 2015, which killed 15 workers. How many of those workers worked for BP? None of them. There were contractors there with Parsons and Jacobs, different construction contractors, others who were on the site. BP's OSHA record is, OSHA logs were very good for that site because none of their people were hurt. So OSHA developed, much to the chagrin of certain employer lawyers, this basic concept, it's common sense, the multi-employer citation policy, and especially on construction sites, you could have an employer who created the hazard, who exposed workers to the hazards, who corrected it or didn't correct it but could have, and who controls the whole site. And all of those, any of those employers could be cited. And that's true in the whole country except for the Fifth Circuit, because the judges in that circuit have said this is not acceptable under the OSHA law, which is a classic problem because the OSHA law was passed in 1970 and nobody really thought about these issues. Within that, of course, is this ridiculous problem of misclassification, which is a huge issue. You may have read the McClatchy series on this, where they actually estimated, using pretty good methodology, that in construction workers in North Carolina, 35% are misclassified, 37%. In those three states, about 500,000 construction workers. So that's meaningful because an OSHA inspector goes onto a site and sees workers on the roof with no fall protection, and the employer, the roofing contractor, says, oh no, they're all independent contractors. That means they have no OSHA coverage, and they have no workers' comp coverage when they fall. And so if they can get away with that, their safety and the safety of other workers is endangered. In the European Union, they call this bogus self-employment. My friendly colleague David Wallet just calls it payroll fraud. I mean, but we see it all the time. And of course, there's the gig economy, and we could call it electronically mediated employment or the 1099 economy. But in terms of safety and health, we know very little. And there's not much work on it, and there's not much thinking about what we can do about it. It's a huge problem. So how should we think about this? So there are some short-term solutions, obviously, to make our preventive services stronger. Stronger OSHA enforcement and penalties. Like, we are so behind on this. OSHA penalties are low. They've gone up finally after 25 years. Congress last raised our penalties. But one of my favorite headlines is in Money magazine, where it says OSHA fines Amazon almost nothing. Because our maximum penalty was $7,000. Now it's $12,000, but still too low. But criminal penalties under the OSHA law are also very, very weak. They're almost non-enforceable. You have to kill a worker in a willful violation. If the worker is badly hurt, there's no criminal penalty, and if the criminal penalty itself is a misdemeanor. So criminal penalties, especially holding CEOs and members of boards of directors criminally responsible, would have a big impact. And that is not a pipe dream. They do this in much of Eurasia or of Southeast Asia. Singapore, Australia, New Zealand actually have criminal penalties now for directors. Obviously, stronger enforcement against misclassification, and in particular, the stronger enforcement against labor law violators. One of the great backward steps the Trump administration has taken is to override the Fair Pay and Safe Workplaces regulation that the Labor Department issued, saying that federal contractors should not be labor law violators, that the most egregious labor law violators should not have the privilege of getting federal contracts, and that was overridden using the Congressional Review Act. We obviously need much more protection for temporary workers, and certain states have moved toward bills of rights, and Illinois has a very good one, and increased liability for host employers. And what Mike talked about on the way in, the idea that temporary workers can sue their host employers, that will have a big impact. And we know that fear of litigation changes behavior in very dramatic ways. But those are short-term solutions. None of them are really enough. I think we have to move to a different concept, which is what they also in Australia, New Zealand, and elsewhere, which is this idea of the duty of care, that in the Australian law, it says that you are responsible for the health and safety of those in your workplace, including visitors. If you're self-employed, you're responsible for your own safety and the safety of others. David Wall mentioned cell tower climbers. We had a big issue because we had workers falling from these towers to their death, and they tended to be workers who worked for very small employers, 3 guys in a pickup truck, who would get a contract, which was a subcontract from a subcontract from the company that owned the tower that had a contract with Verizon or AT&T. And so we could issue, these workers often drove 12 hours to get to the job. They were the low bidders. They were getting minimum wage, and they were doing the job in a hurry because they weren't getting paid much, and they died. And we could issue a big fine against this little company, and it would have no impact. And we said, we have to look at this differently. And so I reached out to the FCC, and we put together a meeting with Tom Wheeler, who was the chair of the FCC, and Tom Perez, who was the Secretary of Labor. And we assembled many people in the industry. We said, we can't have workers being killed so everybody has better cell phone service. Everybody has a duty to be involved in this, and it has to go down from AT&T and Verizon and Sprint all the way through the system, because everybody's responsible. And it actually had a big impact. So and by the way, the Global Reporting Initiative, which on the panel that is putting together new disclosures around worker safety, have now a new category. You have to report on injuries, not just among your employees, but among your workers, all the workers who you affect. So the bottom line here is, if you're endangering workers or others, it doesn't make a difference how you're employing them, how you're paying them, or even if you're paying them, you have a responsibility to make them safe. So thank you so much.
Well, thanks to the Academy for inviting me. Of course, I'm here from Pittsburgh. I also teach at Pitt Law School, where we have a workers' comp program, a few courses and internships and whatnot. And I always tell my students, for comp, Pittsburgh is kind of ground zero. kind of where it all started with the great crisis of uncompensated work injuries and deaths right downtown Pittsburgh. There's a state historical marker right downtown talking about the year 1906, 1907, where there were over 500 work deaths, all men, right in Pittsburgh. And of course, Crystal Eastman came to Pittsburgh and studied those deaths and tried to determine whether the widows and children got any comp. And to a great extent, they didn't, of course. And so we have a state historical marker to the origins of workers' comp right downtown where I live and work. So my job is to talk about, well, when safety does not work, how does the social insurance of workers' comp interface, particularly with non-standard work. And that is a big issue for us, not just academically as lawyers and teachers, but right there in the trenches of litigation where I work every day, because when a non-standard worker gets hurt, as we've already talked about in the first couple panels, something unusual has happened. Someone has been set up as a alleged independent contractor, and so employee status is denied, right? Someone has been paid under the table, and the insurance company doesn't know about the worker and they don't want to pay. Someone is in a completely unforeseen category as a worker, and no one wants to say that they're the employer, right? So we heard some stats and talk that some people like being independent contractors. Some people like working in the gig economy. There's freedom, right? There's the freedom to be an entrepreneur. But what happens and what we see is like a workers' comp judge such as myself, then something terrible happens. There's an accident, right? And there's no insurance. There's an alleged employer and they show up in my court. Amputations, brain damage, injuries, and whatnot. So it's a big issue for us in a very real way in the disclosure, in the trenches of litigation. I should note a disclosure, all opinions are mine and not that of the Commonwealth of Pennsylvania. When we talk about who among the workforce, what are they in the eyes of the law? Of course, workers can be an employee, workers can be independent contractors. There's also something in comp we talk about casual employment. That will become pertinent in a moment. There are also workers who are volunteers, right? And all these people can have injuries in the midst of their labor and they show up in court, right? As Dean Weil talked about in workers' comp, however, we cleave closely to our hearts the notion that a worker has to be an employee before he or she gets workers' comp, right? And that presents problems in non-standard work because a lot of workers are not considered employees. Of course, I think we'll be talking about this later. I think Michael wants to talk about it. Harris and Kruger have a paper now 2 years old, a proposal for modernizing labor laws. They conceive of, well, in this new economy, maybe there should be a new category beyond these four, and that is the independent worker. And we should adjust our social insurance laws and other protocols to accommodate workers who don't fall into the category of employee. And in fact, they have a proposal for workers' comp. They think that particularly with the gig economy, platform-based enterprises should be able to opt in or opt out of workers' comp. Opt in, provide worker comp benefits just like enterprises have for 100 years. Opt out, be liable, which is what all enterprises are that aren't employing their workers and employees, and that is potentially be liable in tort and pay workers tort damages for their work injuries. The problem with that, of course, is that they're not going to get workers injured like that, are not going to get any prompt remedy, which is what no-fault workers' comp with mandatory insurance is all about. That's the whole purpose. A piece of scholarship that is well known in the workers' comp community is by Dr. Howard, the head of NIOSH, Non-Standard Work and Worker Health and Safety. So certainly I have all my students read that. It gained great publicity and notoriety in the workers' comp community in the last 18 months throughout the country. Dr. Howard talks about, well, the traditional standard work, of course, is the industrial model, employer-employee, full-time, the craft model, people working through labor unions. Those two types of standard employment are easily handled by the workers' comp insurance policy and models of employment, traditional employment. He categorizes non-standard work, of course, we've been talking about this, temporary, staffing worker, leased workers, big problem in our field, workers in the gig economy, and then I would add individual entrepreneurs, a type of work said to be also on the rise. People setting themselves up as little entrepreneurs in their houses and whatnot, doing what? Like having little home-based factories with 3D printing or whatnot. I'm not sure that's the biggest issue yet, but it's one we talk about. We're waiting for accidents to happen. We're waiting for their workers to show up in workers' comp court. So what does the law, we've been talking about this before, what does the law say about temporary and staffing company workers? Generally, a good temporary firm is carrying the workers' comp insurance, right? Even if they don't control the labor at their clients, that's the value that a temporary service client gets, is that you get the worker along with the workers' comp insurance. Usually not a problem. The vast majority rule is that both the temp service then and the temp service client, the actual entity controlling the work, get the benefit of the exclusive remedy. Their only liability is workers' comp. The new case that came from Wisconsin would be a break from that general rule that Michael started off the presentation with. I saw one response to that by some lawyers in Wisconsin dismissing it and saying that, the legislature will fix that to make sure that immunity endures for the temp agency client, or that the Supreme Court will reverse it. In any event, it's definitely the minority rule. Leased employment is kind of like a temporary service. I think everybody in the room knows what a employee leasing company is, and that is where the enterprise actually employs its clients' workers, right? And one reason that that's a profitable business is that such enterprises, PEOs, employee leasing companies, can buy the workers' comp insurance in bulk, and that's a big benefit to the client. The problem we see in workers' comp is, over the decades, that the employee leasing entity often doesn't buy the workers' comp insurance. There's a terrible accident. They show up in a courtroom like mine, and the employee leasing client says, we don't have any employees, and we don't have any insurance, right? So it's a big problem. With regard to work injuries and workers in the gig economy, we don't have lots of law yet. The leading academic tract on this is from the National Employment Law Project. They have a policy brief arguing that workers like Uber drivers should indeed be covered by workers' comp insurance somehow. I have a student who wrote a very nice article on this same issue. At NELP, they argue that even though workers laboring in the gig economy are a challenge, there are some models that can be followed, particularly the Black Car Fund. That's that enterprise which the next speaker will be talking about, where a specific industry that look like independent contractors perhaps, nevertheless pool together and have a fund as their employer, which in turn buys insurance, and by that means workers who are kind of in the middle can be covered by workers' comp insurance, in the middle somewhere between employee and entrepreneur. So time limits me. I just did want to say that indeed, as Dean Weil talked about, we in workers' comp put the employee status on a pedestal. The worker has to be an employee before normally workers' comp coverage applies. We also put control on a pedestal. Control is king in most states. If someone's set up as an independent contractor, there's a work injury, we look, number one, and number two, number three, control. If the answer is that the putative employer controlled the work, they're probably going to be an employer for workers' comp purposes. But there is a subsidiary test set up long ago in some state courts to take into account the reality that many workers are set up as independent contractors, and that's the relative nature of the work test. We ask, is the worker's work integral to the putative employer's business purpose? If the answer is yes, that enterprise may indeed be an employer. New Jersey is such a state. Finally, since I'm out of time, I thought I would talk about one thing. Workers' comp laws can be written and amended to include certain types of workers. We know, for example, in my state, volunteers are covered for some purposes as workers. They're not employees, but we make them covered by insurance, and those are volunteer firefighters. In Alaska, the Labor Commission, of course, told Uber, your workers, your drivers are employees, and so Uber pulled out of Alaska because they were not going to cover their drivers as employees for workers' comp purposes. Well, last year, Uber, I guess, had the juice. They went to the Alaska legislature, and now workers in the transportation network companies like Uber are not employees. It's right there in the workers' comp statute, right? So workers' comp statutes can add people and take away people from coverage. So there is some flexibility within our laws. So thank you.
Hello. I'd also like to thank the Academy for having this great, I think, session. I think non-standard work is a discussion that we need to be having across the country. And my topic, I'm going to switch now and talk about what are some of the policy solutions that we might talk about in covering non-standard workers. So clearly the panelists here did a good job of discussing that there are a group of workers in the labor force that have the same, if not greater, risk of occupational injury and illness. And those workers exist outside of the legal framework of the workers' compensation system. And so I'm going to discuss some mechanisms both within the workers' compensation context and also outside of workers' compensation that might be used to extend and enhance coverage for these work-related risks. I think it's important to put this conversation in context. This discussion is not new. The first workers' compensation laws in the country were voluntary laws, so they did not in any way consider covering the entire labor force. And over the past century, we've seen a trend for workers' compensation to be compulsory, with a few exceptions, mainly Texas. But there are still a lot of exclusions that exist in state workers' compensation laws and continue to be written into laws, as Judge Torrey just talked about. And this is a quote from more than a century ago, almost a century ago. It's the 1919 IAIABC annual convention. And I think it just kind of illustrates the need for why we're having this conversation. An individual worker who suffers an occupational injury or illness can have a devastating impact on that person and that person's family. But when we have a mechanism to share the cost and to spread that risk across the labor force, that's a benefit not to just that individual person, but also to society writ large. So I'm going to talk about some mechanisms now that are in the current marketplace that we might be able to look to as serving as models and templates to covering these non-standard workers. So the first one, which Judge Torrey alluded to, is the Black Car Fund. The Black Car Fund was created by the New York State Legislature in 1999. And it provides a statutory mechanism for black car fund drivers in New York State to purchase and have workers' compensation coverage. The Black Car Fund is essentially what happens is dispatch organizations become members of the Black Car Fund, and then all of the drivers within that dispatcher become employees solely for the purposes of workers' compensation of the Black Car Fund. The fund is the funding mechanism is a 2.5% surcharge on all black car rides. So it's actually funded by the rider and the customer. And if we think more generically about this concept, it is analogous to sort of a guild or industry-specific model. So you can envision workers of sort of in similar industries, engineers, hairdressers, transportation drivers, can get together and collectively purchase workers' compensation coverage. The benefit to the Black Car Fund that a lot of people see is that it's less disruptive to some of these platform models because these drivers are still considered for all other purposes independent contractors, but they're considered employees for being able to purchase workers' compensation coverage. And just to give you the extent of coverage, there are 70,000 transportation drivers who are covered by workers' compensation by the Black Car Fund. So this is not an insignificant number in New York. Another model that we can look at that sits outside of the workers' compensation context is occupational accident insurance. These are private insurance policies that are often used in high-risk industries where we see a lot of individual operators, independent contractors. So they're very oftentimes associated with the long-haul trucking industry. And essentially, the independent operator, independent contractor, they're responsible for purchasing the occupational accident policy, and then that policyholder is eligible for medical and wage replacement benefits if they suffer an occupational injury or accident. We've seen this model come to the transportation networking company. Uber offers in many of the states that it's doing business the driver injury protection program. This is just their flavor of occupational accident insurance. And essentially, Uber drivers can sign up for the program. They pay 3 cents a mile and get coverage if for an injury or illness that happens while the app is on. I think it's really important, though, when we look at occupational accident insurance, both from a policymaker perspective and also from a consumer perspective, that people recognize that occupational accident insurance and workers' compensation are not equal. I think there are times when there's a confusion about that. Occupational accident insurance policies typically have benefit caps, both on the total benefits and on medical care and wage replacement, and which we don't typically see in workers' compensation. Also, occupational accident insurance policies do not consider vocational rehabilitation or concepts that we have in workers' compensation like permanent partial disability and total disability. Another model that could be used to extend coverage to individuals in non-standard work arrangements is related to disability insurance. Disability insurance provides wage replacement benefits for those individuals who suffer a sickness or an illness in which they can't work. Typically, disability insurance policies exclude work-related injuries or illnesses. However, there are a lot of private insurance products where if the individual is not eligible for workers' compensation, or for example, they're an independent contractor, then an on-the-job injury or illness would be covered. And so we can envision expanding or extending disability insurance policies to include work-related incidents for people who are in non-standard work arrangements. There are 5 states that mandate disability insurance: California, Rhode Island, New Jersey, New York, and Hawaii. And California and Rhode Island, the disability insurance programs are public insurance programs, so they're run through the state. And they're the programs in California and Rhode Island are 100% funded by worker contributions. So they're automatically taken out of the paycheck and go to fund these public disability insurance programs. A lot of people point to California and Rhode Island disability insurance programs because the administrative cost for these funds is very, very low. Again, though, disability insurance and workers' compensation are not equal. There are caps, as you see here. There are weekly benefit caps, 52 weeks in California and Rhode Island at 26 weeks, which we don't have in workers' compensation. And also, there's no consideration of permanent, partial, or total disability or voc rehab. And then finally, I think we've all heard it talked about. I think we're going to probably continue to hear talk about this concept of portable benefit accounts and how that might interface with the workers' compensation system. This is really the hot topic. Last week, Uber's CEO, as well as the president of the Service Employees International Union, came out with a joint letter basically calling on states to be innovators in this area. And we saw the first state legislative proposals last year related to portable benefit accounts in Washington state. So portable benefits, essentially the concept is that we are de-emphasizing the employment relationship. So we're tying benefits not to the specific employer, but actually to the employee or the worker more specifically. There are 2 models that are being piloted in the caregiving sector offered through care.com, as well as the domestic worker sector through myalea.com. And these caregivers and domestic workers have access to portable benefit accounts, which are funded by the customers or the clients. And then these accounts can then be used to purchase health insurance coverage, disability insurance policies, paid leave policies. And I think that there are lots of different funding mechanisms that we could see with portable benefit accounts. Essentially, these accounts could be funded by multiple platforms, by multiple contractors. We might envision a situation where the worker themselves pays into the account, and then what types of benefits they can buy with that account would probably be determined by public policy as well as by the individual platforms that are contributing. And I've run out of time, so I'm going to quickly go forward. I think that each of these models could serve as a template, and I think we're going to see innovation happening in different states in different ways. But the question really needs to be informed by what are the public policy goals? What are we trying to accomplish? And I pose really 3 questions that need to be asked in order to inform how these mechanisms develop in the future. The first is universal coverage. And I think the question is really quite simple. Do we want all employees, that's the current status quo, to have occupational injury and illness coverage, or do we want all workers to have access to coverage? If we can answer that question, we can design solutions to cover people outside of a traditional employment relationship. When we look at benefit levels, workers' compensation benefits are enshrined in statute. That ensures that all workers who are covered under a workers' compensation policy within a state have access to the same level of benefits. When we look outside of workers' compensation solutions, disability insurance, occupational accident insurance, portable benefit accounts, there is a non-standard, we don't know what the benefit levels. So is it desirable to have some minimum standards across these different solutions? And also the long-standing question, which the system has grappled with, is it desirable to have a more standardized or minimum level of benefits across jurisdictions? And then lastly, and probably most importantly, is how are these policies going to be funded and who's financially responsible? And I think that financial responsibility is a really key question, because as most business owners will tell you, if there isn't a financial incentive to do something, they're probably not going to do it out of the goodness of their heart. And so, you know, how we link coverage for occupational injury and illness and occupational safety and who's responsible for keeping these workers safe, I think gets to the question of financial responsibility. So thank you very much, and I now will turn it over to Michael.
So please pass any questions you have to Alexandra as she walks around the room. While we're waiting for cars to arrive, I want to very quickly talk about the paper that Seth Harris and Alan Kruger put out, recommending or proposing a third category of worker who would be entitled to collective bargaining rights, civil rights protections, and the ability for their intermediaries to pool the workers to create some sort of insurance fund, but they would not be entitled to the other benefits of employment, minimum wage, overtime, and such things like that. So to what extent do we need a third category of worker? You know, or can the current categories of employee, independent contractor cover the types of relationships that have arisen? Who wants to start?
I guess I'd take a stab at that. Of course, it's an excellent tract. The workers' comp component of the paper, well, I should say, it seems to me when the authors get to workers' comp, they say, uh-oh, workers' comp, that's that troublesome state-run program. It's social insurance, but that's private insurance companies undergirding the system, right? So it seems to be in its own category vis-a-vis other social insurance programs. And they seem to kind of punt, in my humble opinion, and they say, well, platform-based entities should be able to, I guess I'm just repeating myself, should be able to opt in or opt out and become, and they opt out like they are now, be tort liable. And to me, being tort liable is not a model that is delivering a social insurance product at all. Workers' comp, a no-fault mandated social insurance plan to me is better, and great paper, and I want to say yes, there should be a third, a different category, but their remedy with regard to work injuries seems rather unsatisfactory to me.
I'd comment on that as well, and I think for the purposes of workers' compensation, I don't think you could design 5 different more categories of worker, and it's still going to be a game of whack-a-mole, because people are still going to try to figure out how to get around, is it an independent contractor, is it a dependent contractor, is it a dependent worker? I mean, I think it just expands how creative people are in terms of saying, how can I classify this person so that I don't have to pay coverage? I don't think for the purposes of workers' compensation we need necessarily a new classification. We just need to decide, is universal coverage actually desirable? And if it is, it doesn't matter how we classify them from an employment perspective, which I think in other contexts this makes a lot of sense, but we can design solutions to cover all workers. So, that's my perspective.
Some questions from the audience. The first one is, what is the situation for creative workers, dancers and dance troupes, actors and musicians, and are there precedents here that might apply to other types of non-standard work?
I think most creative workers would be, many of them are covered by unions, and most of them would be considered employees and would have workers' compensation coverage.
Okay, and then the final question, I guess, will be, what is the role of consumers? And how, I guess, I mean, the other part of this I always ask, because this comes up a lot in journalism, where the response is about, this is kind of the similar question we get, and I wonder about, how well are consumers informed, and should there be efforts to make them more informed? Go ahead.
One of the regulations that we issued in the Obama administration was to require employers to send injury information to OSHA with the idea that it should be put on the web. Because that information, the disclosure of that information would provide information first to workers to know what the risks are of injury in different workplaces, so prospective workers can choose to go to safer places, and for consumers who can say, well, this company has higher injury rates, and if you're buying products from them, are they as good quality, for example, if people are being injured. But for this particular venue, the delinking of workers' compensation and injury prevention is very troubling. And in some ways, the workers' comp industry, which fought against this and fought against any transparency, they've been abdicating any interest in prevention. In fact, Liberty Mutual just closed down their safety research center. It was a world-famous one. And we sort of have it upside down here. I mean, the workers' comp system should be actively involved in promoting prevention and safe workplaces, and they're not doing that. We had a program at OSHA where in the worst cases, what we call the egregious cases, where a worker was killed and fines were high because the situation was terrible, I would put the name of the workers' comp carrier in the press release for the public to see it. And I would get phone calls. I remember one from an executive, a very well-known workers' comp carrier, saying, you put us in the press release. We didn't have anything to do with that. And I said, exactly. Traditionally, workers' comp has provided experience rating and underwriting and industrial hygienists and safety experts to help prevent injuries, and they're going in the wrong direction. The German workers' comp system, which dates to Bismarck as the first one, has 3 priorities in this order: prevention, rehabilitation, and then compensation. And we need to be reversing things and thinking about this. How do we use these systems to make sure people are safe in whatever category of work they're in? We need to be linking up major prevention systems from workers' comp rather than keeping it sort of as simply as a social insurance system on the side.
And John, do you want to, I'll be the radio host and say, in about 20 seconds, can you address this?
Well, I was just nodding with David because I wrote a doctoral dissertation on the link between workers' compensation and safety and the importance of experience rating. And to Jennifer's point about financial responsibility, it's important that there be a linkage between social insurance and safety and health, because otherwise the responsibility will not be in the right place.
Great, and so we are now going to have a 5-minute break. They have asked everyone to try to get done what they need to get done very quickly and return here at 11:15 for the next panel.
By the way,